The recording has been started.
All right, thank you and good afternoon. This is a hearing in the matter of the encroachment permit application number L97S1212 for the applicant Kristen Lee Ellingson, case number CC-2022-NAV-10-001. And so I'm the hearing officer for this hearing. My name is Lincoln Strawn, and I'm in Boise, Idaho, a couple blocks from the Capitol. And so we'll be discussing the application of Kristen Lee Ellingson and her application for a single family dock permit on her property. And then with the objector that we have Darla Borey for the Bob and Shirley Hauling Family Trust. And we also have the Idaho Department of Lands on the hearing, Miss Angela Kaufman and their witness, Mike Hamer. So just a few preliminary items to continue to go through and then give everyone a chance to talk. First, let me confirm, is Miss Ellingson on the line, on the call?
I'm here, Mr. Ellingson.
Mr. Ellingson, I apologize. Okay, and what is your first name, sir?
Kristen.
Okay, gotcha. All right, sorry for that mix up. So we have the applicant here, and then I see Ms. Borey on the line. So just confirm that you're here as the objector, correct?
Yes, but I have other family members that have joined the meeting, so I'm not speaking exclusively in behalf of the family. I had done the writing in behalf of the family, but other family members are here to tell their opinions and perspectives as well.
Okay, thank you for that. And then from Department of Lands, I mentioned Ms. Kaufman and Mr. Amer. Ms. Kaufman, do you imagine anyone else is going to speak during the hearing for Department of Lands?
No, I don't anticipate that.
Okay, all right. Well, just to let the parties know, I have reviewed the application. I've reviewed the exhibits that were submitted by the parties, and I am admitting all exhibits that were submitted as part of the official record of this case. I have looked over the application, and so I feel like I have a good idea of the reasons for the objection. And so I have notes down beside me. I know, these Zoom hearings are somewhat uncomfortable for people, but we kind of do them a lot and are used to it. If any point during the proceedings, if you can't hear something or if you need a break or something of that nature, please feel free to speak up. This is an orderly procedure, but it does not have to be any more formal than necessary. We just want to discuss the issue at hand and make sure everyone gets a chance to say what they need to say. So, I have a camera on me here. When I'm looking out in the distance, I have all the documents on computer that I'm looking at. So if you see me looking off at an angle or something, I am paying attention. I promise. I'm just looking at the specific documents regarding the case. And again, I may look down from time to time to jot some notes. So that's pretty much it. This Zoom proceeding is recorded. And again, it's part of the official record of this case. So anyone planning to speak on the hearing as a witness will be sworn in. Sometimes we go all the way around the room first to swear everyone in at once. I don't think we'll do that this time just because it seems like we have some folks that may speak or may not speak during the hearing, and I'd rather just swear people in as they participate. And I think that'll work just fine going forward. So the way this will work is I'll go around and give the applicant, the objector, and Idaho Department of Lands to make some sort of opening statement if you wish. You do not have to make an opening statement. It's just to give you an opportunity to kind of give an overview of your position. The formal testimony will then go first with the applicant, then with the objector, and then with the Department of Lands. Don't feel like it's your only chance to talk. We'll try and keep this flexible. If you think of something else that you meant to say and to get a chance to, I'll make sure to come back to you and give you that opportunity. So with all of that being said, I appreciate your patience, letting me kind of set the stage of how this will work. And we'll go ahead and first, again, opening statements as voluntary if you want, and then move into testimony. And if you're more comfortable off camera, if you want to turn your camera off, that's fine. Really it's however you feel most comfortable participating, as long as you get a chance to say what you need to say. So with that in mind, let's go to the applicant, Kristen Lee Ellingson. One, do you swear to tell the truth, the whole truth, and nothing but the truth today?
I do.
All right, thank you. And again, this is voluntary. You're going to be going first with testimony anyway, so you may not want to say anything yet, but do you want to make an opening statement at this point?
No, wait.
Okay, that is fine. Ms. Bory, I know that you said you're not speaking exclusively for the family objectors, but let me just ask you, do you swear to tell the truth, the whole truth, and nothing but the truth when you do speak?
I do.
Thank you. And do you or any of your family members want to make an opening statement at this point?
I do.
Okay, and what is your name?
Carl Halling.
All right, Mr. Carl Halling, do you swear to tell the truth, the whole truth, and nothing but the truth today?
I do.
All right, go ahead and begin.
All right, well, first of all, I'd like to correct their application for the dock statics. Instead of 71 feet, it should be 74 feet long. For my purpose of us having this discussion is that the reason why we're here is that we would like to have Mr. Ellingson move his dock further away from our property line. And the reason for that is that with his dock that large and in that proximity, that close to our property, we feel that it increases congestion to the area where our grandkids, kids swim. And so this is really the purpose that we're here, is to consider increasing the distance from our property line, his dock presence.
Okay, thank you for that. All right, Ms. Kaufman, Mr. Amer, was there anything that you wanted to say for Department of Lands before we get into testimony? And Mr. Amer, while we're on you, do you swear to tell the truth, the whole truth, and nothing but the truth today?
Yes, I do.
All right, thank you. Ms. Kaufman, Mr. Amer, anything you want to say at this point?
No, I don't think we have anything to say by way of opening statement. I'll just note, since we're being recorded too, I'm in a similar situation to you. I'll be glancing over at my other screen to look at documents, or perhaps looking down to take some notes, but I want everyone to understand I'm not meaning to be disrespectful to anyone that might be speaking. It's just the way my setup is.
Sure, okay. All right, with that being said, let's go ahead and get into testimony, and we'll go to the applicant. And Mr. Ellingson, if you have anyone else that you want to speak on your behalf or with your presentation, you're welcome to do so. Just let us know so I can swear them in. You don't really have to say anything particular at this point, but obviously you have an application, you know of the objection, you know of this hearing today. So if there's anything that you would like to say at this point to support your application and address any of the concerns raised by the objector, now is your opportunity to do so. So go ahead and begin when you're ready.
There was a number of different issues that Darla submitted. So I'm not sure exactly what the final objection is that they have, unless it's what Carl just said. But the dock is 71 feet, not 74. It's within the line of navigation. I understand their concern. They're concerned about their grandkids. I appreciate that. But on 50-foot lots, there's not a whole lot you can do. I'm complying with the law. And so I feel that that the dock permit should be approved because it is within the law. I don't know if I should respond to each one of Darla's objections or not. Is that something that you've seen her exhibits? Is that something that you want to hear a rebuttal on, or is it just moot points?
You can, if you wish, really it's your preference if you want to respond. I could give you another chance after you hear from the objections. I'll note that you say it's within standards of what the rules are and that you have concerns with, or you understand their concerns with congestion and safety. So I'll just take that as a summary that you feel that the proposed dock is within the law and that their concerns, while they may be valid, are not a reason to deny your permit. Would that be a correct summary?
Yes. So in that regard, Darla mentioned that I had a conversation with Kevin regarding the Hollings putting a dock 10 feet from the property line on their side, possibly in the future. And Kevin just mentioned that the reason that my dock shouldn't be on the north side of the property is because his boat was so wide that it might bump into my boat. Well, I don't have a boat. And if Kevin's boat was too wide to sit there and not float over the line, then Kevin would have to put his boat on the other side or move it over, move their proposed dock over. But if that's their plan, they're going to build a dock, then they would have an enclosed area for their grandkids to swim, or to separate the two docks that they have now and have an enclosed area in there. But Darla was saying that I should have the state require the Lindvalls to move their dock over. It's been there for who knows how long, 30, 40 years, and spend thousands of dollars to do that. And there's no way I would ask the Lindvalls to do that because the Hollings don't want my dock legally within 10 feet. I get along great with the Lindvalls. Another issue that Darla brought up. There is no legal shared dock agreement between me and the Lindvalls. There never was. There was a verbal agreement between the Lindvalls and the previous owner of the cabin. But the Lindvalls had no legal obligation to continue that with me, but they did voluntarily. They're very gracious neighbors. And I simply wanted my own dock. So, yeah, that's that regard. I guess I might as well keep going through what Darla brought up since it was submitted as exhibits. My property is a private residence. The fact that it was purchased through 1031 exchange doesn't change that. Doesn't make it a commercial property, doesn't make it a public property. It simply means that I can't use it as a primary residence or a second home, vacation home, for a period of 2 years, according to IRS rules. And I bought the property with the intention of someday possibly making it my primary residence. The screenshots that Darla took of the VRBO rental, the month of June is blocked out, not by renters, it is blocked out by me because I didn't know when Copper Bay could get me on their schedule. The cabin gets closed up in end of October. So everything after that, November and on, is blocked out. That's not from renters, that's by me. The cabin is winterized. Last summer, I had 4 weeks booked through VRBO. That's 4 weeks out of 52. Hardly a commercial enterprise. This summer.
4 weeks where you did rent it?
Yes.
Okay.
This summer, I have 2 couples booked for the summer. So, yeah, it's not a commercial enterprise. It's like dozens of other cabins are on the lake that rent their cabin out for a few weeks in the summer. Let me see if there's anything else I should respond to here. I guess not for now anyway. So yeah, let someone else go ahead.
Okay. And so just to summarize you regarding the concern that its primary uses for rental, you only rented 4 weeks out of the last year's 52 weeks. And you said this coming year you have, I know you mentioned several couples that have wanted to rent it, but how much time do you expect to rent it this summer or going forward in the rest of this year?
One couple has rented it for a week and the other couple for 12 days.
12 days. Okay. All right. All right, thank you. And again, I was just making some notes here. Ms. Bory, let's go to you. And again, I understand that several of you may be talking and that's fine. Did you want to say anything at this point, or did you want to have Carl speak some more? But basically now is your chance to raise your objections. And while you do, I just wanted to know, again, that I did read through your objections and I noticed 6 articulated objections, and let me just read through them real quick, just again to let you know that I have read through them and to give you an idea of my understanding so far, to give you a chance to address anything that I may be misunderstood about. But number 1, that the property is being used as a rental and that potential renters may not be courteous or law-abiding, because you can't really control what kind of people are coming in there and what they'll do. Second concern was that particular part of the lake could cause congestion and lead to safety issues. Third, that the commercial boundary restrictions is 25 feet and it's not 10, and that if it is considered a commercial dock, then applicant would be not in compliance because there would be less than 25 feet boundary. But if it is a 10-foot boundary, you wanted to confirm that the entire dock would be at least 10 foot from your littoral line, and that there's one part of the drawing that is like 8 foot wide section of the dock that might be less than 10 feet from your line. So you wanted to confirm that. And then the fourth concern was that the curvatures of the shoreline on that part of the lake, you wanted to confirm that there would be no infringement based on the curving of the shoreline there and the way the measurements stack up. And then the fifth was the dock length, whether it's 71 feet or 74 feet, and to make sure the effects would not affect the aesthetic beauty from the vantage point of your property. And then lastly, that there would not be an effect on habitat. And so that was my understanding of the 6 different concerns you raised as part of your objection. So you're welcome to speak to any of those. You can emphasize if there's some that are more important to you than others, but now is your chance to speak to your objection. And again, you're welcome to speak as well as other family members.
Thank you. Yes, that was in the written letter that we sent as a formal objection to the application. I just wanted to refer back at one point that Mr. Ellingson was saying that he understood about the congestion we were concerned about, and whether it be with the navigation of boating or whether it be with the kids swimming out there, and we don't know in the future if he's going to have boats or jet skis or whatever the renters are going to be using. You know, once the dock's there, it's grandfathered in, but we're trying to say something to be heard that maybe it would be courteous, and if it's still within the law, to move his dock a little more south on his property to give us a little more space on our side as well. Also, if we wanted to, if we split, we're actually on 2 properties. One of the exhibits that we gave, and I didn't know if there was a way to show exhibits if people hadn't seen them, but one of the exhibits, number 2 and number 3 showed the family lots, the 2 family lots there that are within our family trust. And that it had been surveyed and certificate signed and everything, that it was 2 separate lots. That if we did separate those lots at one point, and the lot that's adjacent to Mr. Ellingson's would be the one that may want to build a new and a dock on that property, would there be space to do that if his was pushed right next to our property line, to that 10-foot easement to our literal property line? Would there be space for that, whoever had that lot, to put a dock? And at that point, what would Idaho Department of Lands say then? I mean, would he have to move his dock over to allow for that, whoever had that lot now, to build their own private dock? So that we'd like you to consider. And if he's within the law where he's putting the dock now, would he also be within the law if he moved his dock further south toward the Lindvall dock and still have plenty of space for everyone swimming and in use of the dock through navigation and everything?
Okay. And would you like to give him a chance to address that now, or Idaho Department of Lands to address that now? Or did you want to express some other concerns?
I would like to speak.
Is there anyone in the rest of my family that would like to say something?
I would like to talk.
Okay, go ahead.
First of all, I agree with things that my sister just said, but to look at this drawing again for the dock is not 71 feet, it's 74 feet. They made an error. Instead of a 4 by 5 foot ramp, they got on their picture a 4 by 8 foot ramp. If you add all the numbers up, it comes up to 74 feet, not 71. Now, this is a moot point, but anyway, he already mentioned that he bought this property as a 1031 exchange. So in order to make that transaction, you can look at, and you guys are attorneys, you know more about this than I do, but it says here a question: what properties can be included in a 1031 exchange? It says, I'm just reading this: a real property like a single family home, apartment complex, or strip mall. These are properties that must be used as pure investment type properties in order to make that exchange. This is exhibit B10. Unfortunately, primary residence, secondary homes, or vacation homes are not counted as investment properties. Now, the purpose of this is that the point is that's not a single family home. And it's not on the application here as he's got it as single family dock. He's got it as a bed and breakfast business. And the way you can prove that it's a business, he's got it advertised on the internet. And you can see that in your B4 through B9 exhibits. We understand and we know that a bed and breakfast does not meet the criteria to fit into the category for a commercial business. So the 25-foot distance is out. He is legal within his 10-foot distance, so we understand that. But it brings, the point is, it's a business. It's not a single family home. And so anybody can come there. You can have people come from California, Florida, Texas, Indiana. You can have actually, because it's on the internet, you could potentially, and I don't know if that ever would happen, but you could have people that are international come in there and use that property. When you have people that you don't know come into a property like that and are renters, you don't know their character, you don't know their expertise with regards to operating a boat, a jet ski. You have no idea. You don't know if these people are going to be partiers, if they actually drink alcohol. And you know that if they drink alcohol and try to run boats or jet skis, it increases risk. And that's the whole point of this hearing, is that his dock 10 feet from our property line increases congestion, it increases risk, and it increases the risk to our young children, our grandchildren swimming in that area. Yes, he's legal. I mean, you can't refute that. But there's got to be a little bit of common sense. This isn't just a single family home dock, okay? If you have inexperienced drivers of these machines, they're increasing the risk. People that don't have boats can go to Hills or Elkins and rent boats. They can rent jet skis and do basically whatever they want. And so the thing is that the presence of the dock, the proximity of the dock increases congestion, increases risk. It's just like if you're sitting around a campfire and it's cold outside. So you're sitting around this campfire, you want to snuggle up to the campfire, but you don't know you're sitting there that a spark can pop out of that pine and fly into your lap. And you're playing a little bit of risk there. The closer you are, the more you're at risk of getting that spark in your lap. So what do? You move further away from the fire and you decrease the risk, you decrease the congestion. The last thing we would like to have happen is if one of our children, by some reason, got injured for these reasons I just mentioned. And it doesn't really do any good to say, well, I'm so sorry, I didn't mean to, etc., as they got below 1 point or 0.1 or 0.8 or whatever it is alcohol level on their breathalyzer test. But that's basically that. The Ellingson discussion that he had with my brother explained to him our concerns and the situation and what we were concerned about, these unknown people coming in and their unknown skills, etc., the congestion, and if he could move it over. And Ellingson just told my brother, he says, I'm legal. I can put that dock wherever I want to. And so let's talk to you about Exhibit B1 and B2, the Lindvall dock. He already mentioned that he shares that dock. I didn't know any of the agreements with regards to the dock, but the point is, this dock is an illegal dock. It's right on the property line. I bet you could hardly fit a quarter between the line and the edge of that dock. That dock is an illegal dock. And if Ellingson wants to build his dock on the southern end, he could build the dock on the southern end, but the Linville dock would have to be moved to the legal distance, 10 feet from that property line. And we already know that this has been done in that bay because a guy by the name of Brian Martin had an illegal dock. And there was somebody in that bay that wanted to build a new dock, and he had to move his dock to accommodate the new builder because he had an illegal dock. I understand there's expenses involved with regards to moving the Linville dock, but right now there is no money that could pay for an injured child because of increased risk and congestion for the reasons I mentioned. So a solution that could possibly be on the table would be to have the Linville dock moved to the legal spot, and Mr. Ellingson then could build his dock 10 feet from that property line. He would have plenty of swimming space for his guests, his bed and breakfast guests, and there would be no issues. That's all I got.
May I say something?
Yes.
I agree with my brother. I think the family is on board with all those issues. I just wanted to make note for you all, if you were looking at the exhibits. Originally, when I was sharing them with family, I had them certain numbers, but for your purposes, the ones I submitted for the hearing, he talked about the 1031 exchange. That's exhibit number 6. The website exhibits Carl was talking about were number 8, number 9, number 10 and 11. And then the proposed dock placement was the number 1. Yes. Thank you.
Okay, thank you. And yeah, I was looking over the exhibits right now, and so thank you for that clarification. All right, and so you're talking about risk, and so are you feeling the solution would completely address your concerns if the docks were moved, or it would just lessen the risk?
It would actually do both. Yeah, there's no way to ever make 0% risk. But if you move the docks, you have decreased congestion, you have decreased risk. And that's basically simple. In fact, if he was able to build that dock 10 feet from that property line, which in my opinion doesn't make any difference which side of the fence he goes to, he should be totally happy. The only downside of this whole thing is that you've got an illegal Linval dock. And to move that dock is going to have some money attached to it.
Okay. Is there anything else the objectors would like to say at this time? You'll get a chance to speak again if you think of something else, but at this time, was there anything else you wanted to say? No? Okay. All right. Ms. Kaufman, let's go to you and Mr. Amer for the Department of Lands. Ms. Kaufman, was there anything else you wanted to say at this point, or do you just want to have Mr. Amer speak?
I think at this point, I'll just defer to Mr. Amer and have him go ahead and speak.
Okay. Mr. Amer, when you're ready.
Okay. Hello, my name is Mike Amer, Mr. Hearing Officer. I want to address a couple things that were brought up earlier during the hearing before I get into my statement. First, Mrs. Dory made a comment or a question. If their property split, would there be allowed to be another dock on that parcel? And the answer to that question would be yes. Right now, the applicant is providing a 10-foot buffer. And it's not that the proposed dock is going into the objector's property. It's 10 feet from that buffer. So the objector would be able to make application. If they provided a 10-foot buffer, there'd be 20 feet between docks. And we see that in several locations throughout North Idaho Lakes where there is only 20 feet between docks. There's also been talk about the length of the dock. The 4x8 is the length of the ramp, but it overhangs. And so you only count the 5 feet that actually is shaping the
Oh, is
water.
that the way that works?
Yeah, it's kind of like if you're a fish looking up.
Oh.
You don't count the part that overhangs.
Well, I was just looking at his diagram, and over here it says a 4x8, so 8
Yeah.
is different than
It's
5.
very common for people to have a 3x17 or 3x20 ramp that we only count as 3x17 per square foot
Okay.
purposes. That way the ramp overhangs on the dock and allows the dock to float up and down.
Yeah.
And you only count if you're like a fish looking up till you count. And then the Linval dock is not the illegal dock. The Linval dock is permitted. The neighbor at the time was Kusterman, and Kusterman did not object to the dock being placed on the property line.
So you say it is a legal dock?
There's a permit for it. The permit number is 68. And I'll tell you when it was issued here, just a second. It was issued in August of 1995, issued to Linval, and it shows that current dock being right on the property line. And at the time, the neighbor was Don Kusterman, and Don Kusterman did not object to the application. So,
Okay, but now the owners have changed,
but the dock has been permitted. The dock has been permitted.
so it doesn't make any difference at all?
It's not an illegal dock.
It's not.
Mr. Hearing Officer, if I could interpose an objection here. Mr. Amer is trying to take his opportunity to provide IDL's hearing statement. And if there are questions, I would suggest that those could be provided subsequently.
No problem.
Yeah, I think that's a good idea. Let's let Mr. Amer get through everything that he wanted to say. And again, the parties will get a chance to ask questions or make comments after, but let's let Mr. Amer get through his full presentation first.
So that is all I had in terms of additional stuff before I read the statement. As is protocol for when we read these statements, I will skip over the sections that talk about the applicable legal provisions to kind of save some time here. So good afternoon. My name is Mike Amer. I am the Lands Resource Supervisor for the Navajo Waters Program in North Idaho of our Idaho Department of Lands. My purpose in being here today is to provide you with information regarding IDL's assessment of application for encroachment permit number L97S1212, filed by Kristen Lee Ellingson, who owns property identified as parcel RP 00445 0000050A on Priest Lake in Nordman, Idaho. The applicant is seeking an encroachment permit for a single-family dock located adjacent to a parcel on the western shore of Priest Lake, which is Lot 5 of Stevens Granite Creek subdivision. The proposed single dock would consist of a 4x26 pier, a 4x5 ramp, and an 8x40 dock with a boat lift, comprising 444 square feet. There is not an existing encroachment permit for this property. Let's skip now to section 3, which is IDL's analysis of the application's compliance with the LPA and LPA rules. Applicant owns a waterfront property on Priest Lake, identified as parcel RP 0044500000050A, lot 5 of Stevens Granite Creek subdivision. Applicant is considered a littoral owner with littoral rights. Applicant is seeking an encroachment permit for a single-family dock. The application type would be considered a navigational encroachment. Applicant owns approximately 50 feet of water frontage, which is sufficient water frontage for a navigational encroachment. See IDAPA 20.03.04.010.36. IDAPA provides that a single-family dock may not exceed 700 square foot of total surface decking area, waterward of the ordinary or artificial high water mark. Applicant's proposed dock, as stated before, would be 444 square feet. Line of navigability, the proposed single-family dock would extend outward into the lake 71 feet. The proposed dock is approximately the same length as adjacent docks in the area and would be within the line of navigability due to the contours of the shoreline. The 3 docks to the south were measured at 70 feet, 80 feet, and 80 feet. The 3 docks to the north were measured at 60 feet, 70 feet, and 70 feet. IDAPA provides in pertinent part that single-family docks will have an adverse effect upon adjacent littoral rights if located closer than 10 feet for adjacent littoral right lines, which is subject to rebuttal. The proposed dock appears to provide a 10-foot buffer to the north and a 20-foot buffer to the south, which meets and exceeds the minimum required by IDAPA. I'd also like to point out that the applicant needs to ensure that the 8x40 section of the dock adheres to the 10-foot buffer, and not just the 4x26 pier ramp, but the 8x40 section, which appears to be wider, obviously, than the 4x26, that needs to adhere to the 10-foot buffer. In conclusion, IDL recognizes that there is a single-family dock on the applicant's southern property line shared with Lindvall, and that dock may have been used by both Lindvall and the applicant at some point in the past. That dock is currently permitted as L-97-S-68B. IDL cannot force or require that the applicant and Lindvall move the proposed dock and the existing dock on the property line further south to provide more room for the Holling family trust property. Additionally, IDL acknowledges the concern raised by the objectors and adjacent neighbors that the property is rented out as vacation rentals through VRBO. The adjacent neighbors provided IDL with the VRBO listings for the property in question. The LPA and LPA rules do not specifically address the status of vacation rentals. IDL notes that there are likely numerous waterfront properties in North Idaho rented out as vacation rentals, from along the St. Joe River all the way up north to Priest Lake. However, renting out a waterfront property, including a dock, does not appear to violate the existing LPA and LPA rules. Significantly, the mere fact that upland property is being rented does not necessarily mean that the renter is using a boat or the dock, as some renters may just want to enjoy the upland property, the view, and shoreline for swimming. In addition, IDL cannot determine if the renters are using the dock for moorage each time it is being used. Not all renters may use the dock for moorage, but rather simply may be using the dock for sitting, swimming, and or lounging. Such uses would not convert a single-family dock into commercial use. The dock drawings that were submitted by applicant all appear to meet the single-family dock standards listed under IDAPA 20.03.04.015.01, which is that the proposed dock is less than 700 square feet in size. The proposed dock is within the line of navigability. No portion of the dock is wider than 10 feet. Additionally, the proposed dock appears to provide at least a 10-foot buffer on both sides of the dock per IDAPA 20.03.04.015.13E. Based on the application provided and IDL's evaluation of the application in light of the LPA and LPA rules, The applicant's proposed dock meets the legal requirements for single-family docks. IDL recommends approval of the applicant's proposed dock encroachment permit application. That is all, Mr. Hearing Officer.
All right, thank you, Mr. Amer. And so you've heard some of the concerns from the objections that were raised, and one of it was a health and safety. Do I take it by the rules and Department of Land's interpretation of the rules is that as long as a dock is within the measurements, the setback requirements and the overall size and so forth, that is considered to be safe? Or are there any other considerations that may come into play?
I believe that what the first portion of your statement with Mr. Hearing Officer, I believe that if it meets the standards for a single family dock, that is what is most applicable. Commercial marinas and community docks are the docks that typically require a 25-foot buffer. Those encroachment types typically greatly exceed or significantly exceed 700 square feet. When you significantly exceed 700 square feet, you have opportunity for a lot more boats to be moored at a encroachment. When you have a lot more boats moored at an encroachment, there's a lot more traffic coming and going. 700 square feet is the maximum allowed for a single family dock. That size of encroachment limits the use to what is typical for a single family residence. This applicant is only asking for 444 square feet, which I would not consider to be a significantly large encroachment. I feel that the use of the dock is very consistent with the use of other single family encroachments throughout North Idaho. IDL cannot regulate the efficiency and accuracy of people trying to boat on the lake.
Okay, and so with that last statement, concerning potential renters that may rent the property and may use a boat or a jet ski or some other watercraft, the rules, if I'm understanding you correctly, do not have a way of regulating potential future users of that particular dock.
I would agree with that statement. The department went through a hearing last year, 2021, on Mr. Oberholzer on Lake Coeur d'Alene. The objectors on that application were also concerned with the VRBO nature of the property. And it was IDL's determination that there is nothing in our rule book that or the Lake Protection Act that regulates or has concerns with rental properties. As stated in my hearing statement, it is unknown how many rental properties there are in North Idaho. There are a lot of big bodies of water up here, from Coeur d'Alene Lake, Hayden Lake, Pend Oreille, Priest Lake. There's lots of lakes and there's numerous vacation rentals. And to date, Department of Lands has not regulated or enforced any of those properties differently. And to be honest with you, Mr. Hearing Officer, I have no idea how Department of Lands would be able to determine where they all are at or how to enforce rules on all those properties throughout the state.
Okay. Thank you, Mr. Reimer. Ms. Kaufman, was there anything you wanted to add or any specific questions you wanted Mr. Reimer to address?
I was just going to add from a legal perspective too, matters of boating safety, which are, I think IDL will be the first to admit they're a significant and justifiable concern, but matters of boating safety, experience of boaters, et cetera, those are regulated under Idaho's safe boating laws, which are typically, and I'm not exactly sure how it is on Priest Lake, and Mr. Amer can maybe fill this in, but that's a matter of local law enforcement. So, that's unfortunately or fortunately, either way, that's just not something that the Department of Lands can regulate. And then one point of clarification in the record, I believe I heard one of the witnesses refer to the property as a bed and breakfast. I don't think that's reflected in the record. It's reflected that it's perhaps rented through VRBO and similar sites, but I didn't see any reference, anything in the record to indicate that the Upland property is a bed and breakfast, which I think would be a different type of facility. But again, IDL has no, in terms of what goes on the Upland too, I would make that point very clear too. The IDL has no authority to regulate what goes on the Upland.
Okay. Thank you. Anything else from Department of Lands at this point?
No, sir.
Okay. All right, Ms. Boyd, I saw your hand come up when Mr. Amer was speaking. Did you have a question for him or something that you wanted to address?
Yeah, I do hope that everyone keeps in mind that I see, you know, Idaho Department of Lands has their rules and regulations for size and for, you know, positioning and so forth, and the navigation from the high water marks and all of these rules. But it seems like on the Idaho Department of Lands exhibit, in the conclusion, third paragraph, it says the LPA and LPA rules do not specifically address the status of vacation rentals. So I think it seems to me like there are no real existing rules to follow. So that's why they're saying it's not an issue. We know common sense that it's being used as a business property. And so that's why we had a little bit of objection to them saying it's a private dock. When you know your owners, you know the owners of people around you, you get to know your neighbors. And there's more pride in taking care of things and in safety. And, you know, it's different from having different renters come in all the time. So that's what we're, you know, appealing in a sense for you to consider. And also in the IDL's exhibit, I'm looking at shoreline length, where it says, this is on page 7, it says the applicant owns approximately 50 feet of water frontage, which is sufficient water frontage for a navigational encroachment. So it seems like, you know, out of consideration, it wouldn't be a problem to move the dock encroachment a little bit south, that it would give, like my brother Carl was saying, less congestion towards the neighbors. And he has plenty of space to do that. I don't know why he wants it specifically way over on the south side, or why the Linval dock had to be way over, you know, right at property line between those two properties. And then on the item D, square footage of encroachments on page 7, there it says that the single family dock may not exceed 700 square feet of total surface decking area waterward of the ordinary or artificial high water mark. The applicant's proposed dock would be 692 square feet in size. That's what it says in the exhibit. I know we're talking about, you've been talking about a different square footage, but 692 square feet in size is almost max of the 700 square feet, you know, permitted size. And then when you go down to E, line of navigability on that same page, he's telling about other single family docks that are 71, 70, 80, 80 feet and 60, 70, 70 feet. And I'm wondering, it doesn't say that those are adjacent to, you know, I'm wondering where along the shoreline those docks of that length are. Now, we had somebody go out and stand on the property, you know, recently to look from our viewpoint and envision how far out the structure that he's wanting to build, how far out that's going into the water compared to, I'm going to call it the hauling dock on our property, and the Linval dock don't seem to be going out into the water that far. Like it's going to be, you know, quite a larger structure. And you talk about aesthetic beauty being, you know, as well, keeping things kind of the same size. On page 4 of the IDL exhibit, it says under encroachment standards on 1C, it says no portion of the docking facility may extend beyond the line of navigability. It says shorter docks are encouraged whenever practical. And new docks normally will be installed within the waterward extent of existing docks or the line of navigability. So I'm wondering where they got these measurements for those docks that were 70, 80 feet out, as I don't believe that our dock is that far out, if they're, because they didn't say where they found those docks that they're saying are go out as far into the water as what Mr. Ellingson wants to build.
Okay, I'd like to address those comments if I may, Mr. Hearing Officer.
Go ahead.
I apologize, the first point about the square footage, that was an error. On section E of page 7, it is still labeled as 692. However, the application and the application drawing clearly shows a 444 square foot dock. That's why during my hearing statement, I read it as 404 square feet. It was just a mistake on our part for leaving that in there. As far as the line of navigability concerns that she raised, the docks that I measured on Bonner County's parcel webpage called Cloud GIS. I measured the 3 docks immediately to the north and the 3 docks immediately to the south. I use that in Google Earth, so that's where I got those measurements from. And as far as the distance from the shoreline and the line of navigability, changes with the contour of a shoreline. So if all of the docks in an area were 60 feet, the 60-foot line of navigability line would follow the contour of a shoreline. If there was a point, then that 60-foot line would bump up with that point. The dock that's generating from that point would still be 60 feet, but it's going to look like it goes out a lot farther because it's generated from a point. And conversely, if you're in a bay, a 60-foot dock is going to look like it's really tucked in, but it's still 60 feet from shore. So it's the length of encroachments that we're concerned with. And as the shoreline curves in and out, navigability also parallels that curvature of the shoreline.
All right, thank you, Mr. Amer. Ms. Maury or any of the other objectors as part of the family trust, was there any other questions that you had for Idaho Department of Lands or any other concerns that you wanted to address?
I have a couple questions. One is, have on there a boat lift, does that affect the square footage of the dock? The second question is that you talk about these other lakes with rentals. Do these other rentals, do they advertise on the internet as a, well, I called it a bed and breakfast. Evidently, there's a difference in bed and breakfast versus whatever it is. But do they all advertise on the internet and say, you know, this is what we have as a business? Because it comes down to the fact is that he's running a business, however you want to call it. It's a business. It's not a single family home. It's a business. It does not meet commercial criteria. We know that. We know that his 10-foot away from our boundary line is legal. We know that. The part that I didn't know was a Lindvall dock having a permit that makes it sit on that line and be legal. There are some holes here that have not been fixed, and there's no way we're going to fix these holes in the law with regards to different categories and things. You go by what you got with your rules, and that's what we have to go with. So anyway, do other vacation rentals, do they advertise through the internet?
Well, I'll answer your first question. A boat lift does not count towards the square footage of a dock.
Okay,
A dock is allowed to have a boat lift and jet ski ports or 2 boat lifts.
right.
If you get beyond that, then we start having to count half of the largest boat lift structure toward the square footage. But very rare for someone to have 3 boat lifts on a single family dock. Usually a single family dock just has 1 boat lift. As far as the VRBOs go, the hearing that I referenced before, it was advertised on the internet, and the objectors in that case provided the VRBO listings as well as on the internet.
Okay.
I still stand by the fact that a family dock is allowed 700 square feet. So you guys have a single family dock property, you're allowed 700 square feet. There's only so much activity in boats that can be stored on a 700 square foot encroachment. Once you get beyond into a community dock or a commercial dock, you may have 10 to 20 to 40 to 50 boats coming and going. That is why you have that different setback. You don't want to be 10 feet away from a commercial marina that has 100 boats coming and going. There should be a bigger setback there.
Right, but that's not what I'm trying to say. I'm not saying he's gonna have 15 boats sitting there. I'm saying that he's got a VRBO, whatever you call it. It's a rental. They can bring in any amount of boats that they want with regards 2, 3, 4. They can have their friends over the boat. It's a business. He's running it as a business. It's not a single family home. It's not that I'm taking the square footage of the dock and lumping it into a certain category. That's what you're doing. You're saying, I've got a square footage that meets the legal deal, you know, so it's not gonna have 4 or 5 boats moored there, blah, 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 to make it a commercial thing. No, it's not. But he's running a business. You don't know how many boats he could have there. You don't know who's gonna operate those boats. Just like you said, you don't know if they're gonna come there and sit on the dock and enjoy the sun. But on the other hand, you don't know if they're gonna be out there partying, drinking beers and have 2 jet skis, 2 boats or 3 boats coming in and out because of their friends, etc. You don't know that. I don't know that. But I do know that congestion, increased risk to those kids. That I do know. And that's a common sense thing. There's no way we're gonna get over the fact that what he's proposing is a legal dock. That it's legal, there's nothing we can do about it. And that's what I'm hearing from you and all your legal numbers and whatever you just said. But we have expressed our affections the best that we can, and that's all we can do, unless you guys have anything else to say.
Ms. Boyer, I noticed there's someone there with you.
My husband, and he just came in.
Oh, okay. I didn't know if he wanted to say something or,
We have to sign it.
oh, okay. All right.
Thank you.
Well, Mr. Amer, I didn't give you a chance to finish addressing any things the objectors may have raised. Was there anything that you wanted to say, or have you made your position on IDL's interpretation of the rules?
I have nothing further to add, your hearing officer.
Okay. Well, let's go back to the applicant and give him a chance to weigh in. It's been a while since we've heard from him, and there's been quite a bit of dialogue going back and forth. Was there anything that you wanted to address based on the concerns that have come up, Mr. Ellingson?
Well, it's not a bed and breakfast. It's not a commercial property. As I said before, there's dozens of cabins around the lake that rent some weeks during the summer through VRBO. It doesn't make them commercial properties requiring commercial setbacks, commercial docks. The concerns that Carl raised, I could raise that about the Hollings. Their kids have been very nice to me. I like their kids, but I don't know how they drive boats. I don't know how they drive after having some beer. I don't know who comes over to visit. The grandkids at some point, they're going to want to learn to drive the boat. How do they drive? I mean, there's risks involved when you have boats in the water. I mean, that's how it is at the lake. But if those concerns prevented someone from having a dock, then no one could have a dock because everyone could have concerns about their neighbors driving. You know, if I move into the property, I might be a terrible boat driver. Should I be denied the dock, you know, with a 10-foot setback because I might be a bad boat driver? I don't think that is, I don't think that should be a reason to deny a dock. And trying to think if there's anything else.
I'd like to say something if you.
Okay, Sam Holman wants to say something.
Okay.
My name's Sam Holt.
Sam Holling. Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth today?
Yes, I do. And my last name is Holman.
Holman. I apologize.
No problem, no problem. So I'm with Copper Bay Construction. We are building the dock for Chris. And the reason we chose the spot we did is because of that big gravel bar that sticks out there. If we move the dock real far to the south and, 10 feet off that property line, the pier, the fixed part of the pier, which is the 4 by 26 foot section, would not go out as far, and then his dock would start. And when they drop the lake in the wintertime, they drop it 3 feet. So on a property like this, there's no room to unhook the dock and put on the shore for the winter, excuse me. So we chose the spot to the north on that gravel bar so that when the lake dropped, it would sit down on the lake bed pretty evenly and not rack the dock and possibly cause damage to it. And on the hauling's concern about the children to the north, with the dock being pushed out a little bit farther, it actually keeps the boats farther away from their shoreline where the kids will be playing, and it should be a little bit safer for them also.
All right, thank you. All right, Mr. Ellingson, was there anything else you wanted to say, or anyone else that wanted to speak on your behalf?
Just that, yeah, I can't move the dock to the south side because the Lindvalls have their dock where it is, and that's where it is. And so I can't put it on the south side. And if the haulings are planning on putting the dock in, then they're gonna have an enclosed swim area for their kids. But again, you can't eliminate all risk based on who might be driving a boat, and that goes for everybody at the lake. So I'm assuming that's why the state made the laws the way they are.
Okay, thank you. Let's go back to the objectors. Was there anything else you wanted to say before we conclude this hearing?
Yes, I have a question. My name is Shelley Holling Johnston, and I received the initial information on the encroachment permit. And in discussion with my cousin Kevin Holling, he said he met with the dock company or at the lakeside property and with the gentleman from Department of Idaho Lands. And on the application, there is a boat lift. And according to the builder, that they were not going to build a boat lift. So I'm wondering why the boat lift is going to be left on the permit if it's not going to be built. And I do believe Mr. Ellingson said he doesn't have a boat. So it's just a valid question. I am curious.
Okay, Mr. Ellingson, do you care to answer that?
I'd like to answer that.
Okay.
Every time we do a dock permit for somebody, they never know if they're going to get a boat lift here or there. So we always put one in so that we don't have to go through the permitting process again for the state. Otherwise, you have to file for another permit to get a boat lift to put out there. So we just do it all in one shot. So 3 weeks, 3 years down the road, wants to get a boat lift, it's in the permit that there's one already on there.
Okay. Any other questions or statements from the objectors? Yes, Ms. Corey?
have another point. I appreciate Mr. Ellingson agreeing with our concern with the risks and safety factor of the closeness, putting it right within that 10-foot easement area. And I'm just asking, since you agree with that and you're wondering, it could be a risk on both sides for us and for yourself possibly. Wouldn't it be within the law again and better for all if to decrease the risk? I'm not saying you would move it all the way to the south side of your property, but just to leave a little more easement to move it over south a little more on your property. And it sounds like with the 50-foot, space of property, there is space to do that and be within the law. And it would just, I would think, be a consideration. And then I had a question, and I don't want to reach out and put anybody on the spot within my family, but because I haven't been at Priest Lake in the winter time, but I have heard that all the docks along there are dry docked by the time that you lower the water level, and it does not harm the docks. So the idea that it has to extend out so far so that it doesn't harm the dock from hitting the bottom of the lake, is anyone in my family, could they speak to that it doesn't hurt the docks to be on, you know, after they lower the water, to be sitting on the lake bottom? I think Kevin might have spoke to that if he was there.
Well, I don't know of any information where the docks have been damaged over the many years that they've been there, where they sit down on the ground, but I don't know about the neighbors south of us about their docks.
Maybe the contractor who's up there building docks?
Yeah, if you look on the drawing, the outer part of the dock there's gonna be 5 feet of water depth out there when the dock is out in the summertime. The inner end of the dock is roughly 3 feet of water depth. So the lake drops 3 feet in the wintertime, so that'll leave the outer end of the dock still in 2 feet of water. So it could bounce around. When we put a structure underneath so it will hit the ground. But it's kind of hard to explain. If a log starts bending, if you hang a log over a cliff for a period of time, the log will eventually break. So you want them to be sitting pretty flat on the ground. The docks to the south of Ellingson, which is the Brian Martin dock in Yvonne DeBill, they float year round. Because they have deeper water there, so those docks float year round, which doesn't put them in harm of damaging the docks. You guys to the north, I believe when I was there the other day, the inner dock was sitting on the ground and lifted up, the outer part sunk down a ways. It's probably fine, but you don't want them to be you don't want to bend a lot because you will mess with the structure of it.
You've been in this business for over 20 years. You've seen it happen on everything.
Ms. Boyer or any of the other objectors of the family trust, was there anything else? No, okay. Mr. Amer, Ms. Kaufman, was there anything you wanted to say in closing?
No, thank you very much.
All right.
No, Mr. Hearing Officer. Thank you.
Okay. All right. Usually like to open it up for public comment. I don't know if there is anyone from the public calling into this to observe or make a statement, but I'll just invite anyone that is listening. If you wanted to make a public comment, you can do so now. Just tell me your name. Nope. Okay. Yeah, I didn't see anyone on this call that wasn't directly related to this case. So at this point, I think we can conclude the hearing. I will consider everything that has been said by all the parties during the hearing, and I will issue a written decision that is a recommendation to the director of the Department of Lands, and I will issue that order within 30 days from today's hearing date. I do thank you all for your participation. And for you folks that live in that beautiful part of the state, I know you're just wanting to enjoy it as much as you can, and so I appreciate your input of everything you've given during the hearing, and I wish you all the best of luck going forward. So this hearing has concluded. Chris, go ahead and stop the recording, and the parties may disconnect as you wish now, because this hearing has concluded.